computer. Awesome. Good morning. Welcome Monday morning. Mr. Edwards, why do you look so sad? Oh my gosh. Wake up. Miss Lewis is ready.
I
Miss
am not
Monterey is
sad.
ready.
I'm more than happy to be in this room with you.
Yay. Come in. Come in. Miss Hill has a huge smile. That's what I need on a Monday morning. Miss McClary and I have already had a chance to talk. Mr. Bernard, so very happy. All right, very good. Excellent. Welcome. Review 1. PowerPoint is posted. If you would like to go through the PowerPoint, if you can split your screen like that, let's go through the PowerPoints together. If you can't split your screen, I will be running the PowerPoint on this side so we can go through it. Hold on a second. Some of your cohorts need to come in. So let me admit, let's just do one swoop where I can admit everyone at one time. So happy to see everyone. So happy that you're going to get a couple of days off at the end of the week. It doesn't suffice for spring break, but we'll take an Easter break, every break we can get as we get ready for the final countdown. Miss Bray, Mr. Lane, Miss Settle, come in. Patterson, Anderson, please welcome. Welcome. Miss Ross, come in. Morgan, Miss Bryce, welcome. Perfect. Perfect. Did I get everybody? Got Mr. Lane, Miss Toby, welcome in. Good morning. Mr. Adams, welcome in. Good morning. Miss Bass, Marshall, excellent. Beautiful. All right, let's see. Can I leave this long enough to get started? Nope. Still have another person coming in. Come in. Okay. Sorry, guys. It's going to take us a couple minutes. We'll get everybody in. We'll get started. This is going to be our first part of our review for the final exam, aka the summative exam. The PowerPoint is already posted. As I built the questions for the PowerPoint, you will notice that the answers are not there. I did that intentionally. So if you're wanting to, because what some of you have explained to me is that you're actually pulling some of the questions from the PowerPoint and kind of creating your own list of questions. And so I did not want to spoil that opportunity. So what you will notice in this PowerPoint is that the answers are not there, to give you a more real sense of being able to work through the problems, and then kind of checking yourself to make sure that you understand the doctrine. We've got 61. We're really close. So let me close that screen. Let me go here. Torts 2, review 1. We're going to go. The plan this morning is to go from contributory negligence to assumption of the risk. All right, got a couple more people coming in. So we're starting from the beginning because it is a summative. Everything that we've covered this semester is fair game. Everything that we have covered this semester is fair game. With that being said, let's jump off with contributory negligence. Anybody have any questions about contributory negligence? Because if not, what I'm going to do is I'm just going to go over the doctrine very quickly. I'm going to hit the highlights of the case that we went over as an example of the contributory negligence doctrine. And then I'm going to have a question. So I'll stop the screen, put up the poll, see how everybody does as they answer the question, and then we'll move on to comparative negligence. So hearing no questions to start us off, let's just go ahead and get started. Let's go back. Got lots of screens happening this morning, so let's move this one down. Oh, you know what? I'm probably not going to be able to do it. All right. Contributory negligence. Everybody can see the screen, right? Thumbs up. Yes. Fantastic. With contributory negligence, that was the first defense. Good morning. That was the first defense that we covered. What are we talking about? We're talking about defenses for negligence. Defenses for negligence. Remember, we started off with the defenses, but with that, we made an assumption, which you learn not to make, but we made one. We assumed that the injured plaintiff who's bringing the suit has established a prima facie case of negligence, right? We've assumed that the plaintiff has established that there was a breach of duty. I mean, that there was a duty, that there was a breach of duty, that there was proximate cause, that there was actual causation, and that there were damages. Because the defenses never come into play until the primary facie case of negligence has been established. So we're assuming that we've got a primary case of negligence, prima facie case of negligence. With that, the first defense we covered was contributory negligence. Harsh. Remember, it's just kind of, it is what it is. It's a situation where plaintiff establishes a primary facie case. Defendant says, maybe I was negligent, maybe I wasn't. But the point is, you, plaintiff, were negligent as well. So how does that look? Plaintiff establishes the elements of negligence against the defendant. The defendant asserts contributory negligence as a defense. The defendant now has to establish their prima facie case of negligence against the plaintiff, right? The defendant doesn't just get to say contributory negligence, let's go home. The defendant has to establish that the plaintiff had a duty, that the plaintiff breached the duty, that the breach of the plaintiff's duty was the actual and the proximate cause, right? So contributory negligence, defendant has to establish that the plaintiff had a duty, that the plaintiff breached the duty, and that the breach of the duty was also the actual and proximate cause. If the defendant does that successfully, then the plaintiff is barred from recovery. Barred from recovery, game over, we go home. Let's go back to the very first case that we started with at the beginning of the semester. That was the Wright v. Norfolk and Western Railway Company case. That was the case, the guy's driving the truck over the railroad, right? Remember, what was so critical in that case was the railway company negligent? Absolutely. Absolutely. Remember, we had expert testimony that came in and said, not only was it dangerous, it was ultra dangerous. The clearing for the crossing for the people who were trying to cross over was insufficient. The warning system was insufficient. There were so many things wrong with this crossing that it was clear that the railway company was negligent. Absolutely. And in fact, so negligent that in this case, we had a $4 million judgment in favor of Mr. Wright. $4 million judgment in favor of the plaintiff. The defendant said, hold on a second, contributory negligence. The court found that the truck driver did have a duty. He had a duty to ensure that his passageway was safe. He had gone over that railway before. He was very familiar with the problems associated with the railway. He understood that he would have to rely on his senses of sound and sight to be able to see if there was an oncoming train. He breached his duty. His breach of his duty to himself was the actual and proximate cause. Therefore, the doctrine of contributory negligence barred. The doctrine of contributory negligence barred Mr. Wright's recovery. Questions about contributory negligence? It's really that simple.
Professor,
Yes.
I was asking, so just to be clear, not all jurisdictions like recognize the contributory negligence doctrine. It's specific ones.
Right.
Or can you bring it in anywhere?
Yes, Mr. Ortez, absolutely right. Like anything else, it is going to be jurisdiction specific. So how is that going to look? I'm getting ready to show you a sample question to show you how it's going to look, because it's going to tell you whether or not you're in a contributory negligent jurisdiction or not. Yeah. All right. So I think this is what I have. Mr. Ortez, go ahead.
No, I was saying thank you.
Oh, okay. Absolutely.
Professor Washington, I had a question.
Yes, please.
I was wondering, it's not necessarily about contributory negligence just as a whole. So we spent so much time on case law. I was wondering, did you want us to cite it in the final exam, or does it not make a difference?
I'm not interested. I think that's a great question. I really don't have any interest in you citing it. If your brain works that way and you're like, oh, I'm popping, this is that case, this is that case. And if you feel comfortable citing it, absolutely. Right. But if you're going to cite it, make sure you cite it correctly. Right. I think we've done a lot of cases, but I think we've done few enough so that you can probably, when you see the questions, you're gonna be like, oh, this is like that case. Oh, this is like that case. But I really don't have any, you're not gonna gain any points or even lose points if you cite it, unless you cite it incorrectly. I hope that helped. Okay.
Yeah,
so I'm gonna do something with this class that I hadn't done yet. So let's see if I can do it accurately. I'm going to launch a poll. You should be able to see the poll now. It's a contributory negligence question. Go ahead and choose your answer, A, B, C, or D. We've got 87% participation. I'm just waiting for everyone else to finish. %92 participation, just waiting for the others to finish. %96, just waiting for 2 more people to vote. Closing the poll at 60, closing the poll at 96%. There's the results. Hopefully you can see the results on the screen. 85% of you chose D, the fourth answer. 5% of you chose C, the third answer. 10% of you chose B, the second answer. The answer is D. Neither Richard nor Joanna will be able to recover. Questions? Hopefully you guys got it wrong, but if there's no questions, we'll move on. All right,
So,
let's move on.
Professor, I'm sorry, I kind of.
Miss Lewis, please, yes.
Yeah, I was just thinking that the reason is D. I just was wondering if that's the reason that I thought it was D was right, because it was a cross complaint and the call of the question was, it was contributory negligence.
Right. Yes, Miss
Okay.
Lewis, that's absolutely right. So in a cross complaint, that means that Richard is suing Joanna. So Richard's the plaintiff, Joanna's the defendant, and Joanna is also suing Richard, right? So they both They are both existing in this plaintiff defendant status. And because they're both existing as a plaintiff, right? And in contributory negligence, if the plaintiff is even 1% negligent, that bars with the recovery. So yes, Ms. Lewis, that's absolutely right. Got it? And that's because
Thank
it's a
you.
cross complaint.
Yes, ma'am.
Yeah? Questions? Nope. All right, very good. How do we get to a rebuttal to contributory negligence? Remember, this was the very first case. Well, not only is it the first case, but this was maybe one of possibly 3 cases where we actually have a rebuttal to a doctrine. What do I mean by a rebuttal to a doctrine? We've got a doctrine that says the plaintiff is barred from recovery if, in this particular situation, the plaintiff is found to even be as small as 1% negligent, right? Plaintiff, go home, we're done. But we have a rebuttal to contributory negligence. The rebuttal is the doctrine of last clear chance. The rebuttal is the doctrine of last clear chance. What is it and why do we have it? The doctrine of last clear chance is an ameliorative doctrine. Ameliorative doctrine. It is a doctrine that is intended to kind of take the sting out of the harshness of the contributory doctrine, right? Because we talked about that. We talked about a guy who's now paralyzed and who's never going to be able to take care of himself, a guy who a jury awarded $4 million in the Wright case now walks away with absolutely nothing, right? No job, no future, no recovery, no reward, no nothing. And that just seemed to be so harsh. So for the jurisdictions who were still holding on to contributory negligence, because there still are jurisdictions, not a lot, but I have no idea where you guys are going to wind up practicing. So there are still jurisdictions that do use contributory negligence. They've also now adopted this last clear chance doctrine. What is the last clear chance doctrine and how does it work? Here we go. Understanding if you've got a defendant who is generally negligent, right? Just basic general negligence, right? And you've got a plaintiff that's generally negligent, right? Just basic negligence. The plaintiff's negligence negates the defendant's negligence, and that's how we have the bar for contributory negligence. The last clear doctrine allows one more round. What's the one more round? Plaintiff establishes a prima facie case against the defendant. Defendant establishes the prima facie case against the plaintiff. Here's the next round. Plaintiff can establish that the defendant was grossly negligent, was reckless, or acted willfully or wantonly, right? So we kind of one up. You see what we had? Basic, then plaintiff ones up and says, yeah, the defendant was more than generally negligent. They were grossly negligent. They were willful and wanton, right? And so now this rebuttal allows the plaintiff, even though they were negligent, the ability to still recover unless the defendant can also show that the plaintiff was grossly negligent, that the plaintiff was willful or wanton, or that the plaintiff was reckless. See what's happening, right? Prima facie case against the defendant, prima facie case against the plaintiff, they kind of negate each other. Second round. Prima facie case for gross negligence against the defendant, prima facie case of gross negligence against the plaintiff, then they negate each other. If the defendant cannot show a prima facie case of gross negligence, then the plaintiff has won. Got it? Make sense? What was the case? That was our Coleman v. Hines case. That was the really difficult case, right? That was the case where you've got the young lady who is hanging out with the young guy. They're drinking all day. They're drinking as they go to this party. They're drinking at the party. They stop and buy beer. Before the night is over, it ends with the young lady losing her life. Right. That was that real eye-opening case. The estate, which was the young lady's sister, brought a lawsuit against the defendant saying negligence because he pled guilty to involuntary manslaughter. The defendant said, hold on a second, she contributed, that was right. The sister said, but hold on a second, defendant, your negligence was just off the charts. You were reckless. You were grossly negligent. Your behavior was willful and wanton. So I should be able to claim something for my sister. And the defendant was able to say, yeah, but your sister was with me every step of the way. So everything grossly negligent that I did, she did. Everything that was willful and wanton that I did, she did. Everything that was over the top that I did, she did. Right. So in that particular case, there was no recovery. However, let's not get to the question yet. Yeah, let me go back. However, this is what I need you to understand. Number one, I need you to understand how the primary case for regular negligence against the defendant is negated by the primary case of regular negligence against the plaintiff. That's contributory negligence, right? But if the plaintiff can one up and show that the defendant was grossly negligent, right? If they can do that, the elements of the last clear chance doctrine are as follows. This is what I need for you to write down. This is what I need for you to understand. Let's set it up again. Contributory negligence. Primary against the defendant, primary against the plaintiff. Plaintiff ones up and says, I can create a prima facie case against the defendant for negligence. So don't kick me out of court yet. Don't kick me out of court yet. Let me use the doctrine of last clear chance to show why I should still recover. Here are the 5 elements for the doctrine. Number 1, the plaintiff, as a result of their own negligence, placed themselves in peril for which they cannot remove themselves. We know that. We did that in this case. This isn't the first time. Number 2, the defendant saw or by the exercise of reasonable care should have seen and understood the perilous situation that the plaintiff was in. Element number 3, the defendant had the time and the means to avoid the injury to the plaintiff. Number 4, the defendant failed or refused to use at their command every reasonable means to avoid injury to the plaintiff. And number 5, the plaintiff was in fact injured as a result of the defendant's failure or refusal to avoid the impending injury. If, as a plaintiff, I can establish that the defendant was reckless, that the defendant was grossly negligent, that the defendant was willful or wanton, and the defendant cannot say the same thing about me. If I, as the plaintiff, can establish these 5 elements of the last clear chance doctrine, then I can still recover damages.
Professor Washington,
Yes,
could you say number 5, please, again?
sure. Plaintiff was injured as a result of the defendant's failure or refusal to avoid the impending injury to the plaintiff.
Okay, thank you.
Yep. Good. Everybody good? Because I can run through them one more time.
No,
That would be
yes.
perfect, actually.
Yeah, can you run through them one more time, please?
The required elements. Number one, plaintiff, as a result of their own negligence, place themselves in peril for which they cannot remove themselves. Number one, right? So we've got plaintiff is negligent. Because of their negligence, plaintiff has now put themselves in a perilous situation and they can't get themselves out of it. Number two, the defendant saw, or with the exercise of reasonable care, should have seen the perilous situation that the plaintiff was in. Number three, the defendant had the time and the means to avoid the injury to the plaintiff, right? That means that the defendant could have actually done something, right? Had the time and the means to actually avoid the injury to the plaintiff. Number four, the defendant failed or refused to use at their command every reasonable means to avoid the injury to the plaintiff. Number five, the plaintiff's injury is the result of the defendant's failure or refusal to avoid the injury. Got it? What does it look like? Go ahead.
Do you mind repeating that last one, please?
Plaintiff was actually injured as a result of the defendant's failure or refusal to avoid the injury. Right. So what do you have? Just look at those five things, right? Even if you can't remember them 1, 2, 3, 4, 5, if you're in a test situation, you get some anxiety. Think about this from a common sense standpoint. Number one, plaintiff put themselves in a position that was dangerous and they can't get themselves out of the position, right? Because if they could get themselves out of the position, that's their duty of care to remove themselves. So plaintiff did something negligently, put themselves in a position of danger. The defendant see, oh, plaintiff has put themselves in a position of danger. The defendant has the ability, the times and the means to, I could save the plaintiff if I want to, because I have the times and the means to do it. Number four, the defendant fails to do it, fails or refuses to do it. And number five, the plaintiff actually gets injured. Get it? Plaintiff put themselves in harm's way. Plaintiff can't save themselves. The defendant sees that the plaintiff is in harm's way. The defendant has an ability, a means, a method to save the plaintiff from the harm that they put themselves in. The defendant refuses to save them, even though they could have, even though they've seen that they're in harm. And the plaintiff gets injured, and the injury is the result of the defendant choosing not to help them. Right? Those are the five pieces that you'd have to show. What does it look like living and breathing? Got to stop the share and got to launch the poll. Wait, hold on a second. Yeah, no, that's not the one. Actually, I don't have a poll on this one. So there's the question. Question should be, let me share the screen. Here's the question. This is a rebuttal to contributory negligence question. This is the doctrine of last clear chance. As a grad student is driving cross country, visiting a friend, she's in a hurry, is driving even when she's sleeping. Student's so tired, she decides to pull over, but she pulls over onto a railroad track. Train engineer sees the student's car on the track, not moving, but assumes that the student will move the car. Once the train is very close to the car, and after it is too late to stop the train before hitting the student, the engineer blows the horn. The student wakes up, but it's too late for her to move the car, and she suffers some personal injury. Can the student be successful? Can the student prevail? And a lawsuit against the engineer, right? Lawsuit against the engineer and the train company for negligence in a jurisdiction that has maintained traditional contributory negligence rules and its ameliorative doctrines. Got it? Can the student succeed? Here's your options. No, the student can't succeed if the jury believes that the student was negligent in stopping her car on the train track. No, the student can't succeed because the student was the actual cause of the accident. Yes, the student can succeed, even if the jury believes that the student was negligent in stopping her car on the train tracks, if she can establish the elements that are required in the last clear chance doctrine. Yes, she can succeed because a plaintiff's negligence is irrelevant. Answers. Ms. Kilgore, you popped up on my screen. You want to walk us through this one?
Okay.
Okay. So let's go 1, 2, 3, 4. Tell me if they're right and why they're right, or if they're wrong and why they're wrong.
Okay. Give me 2 seconds.
Mm-hmm. Sorry, take your time.
Okay, honestly, I'm gonna go with C.
So before you go with C, tell me why you believe A is not the right answer.
Because of what you said earlier about how realistically with the 5-prong test, you will look at, yes, the plaintiff put themselves in that position, but the defendant could have and should have, because they were like completing the torturous act together, I guess, interfered. And so with the grad student, it was negligent to be on the train track. And so, and that goes to like A, whatever, it was negligent to be there, but also there was plenty of time for the train conductor to do more than what they did, which is nothing until the last minute in which they tried to intervene.
Love
And
that.
so it goes to I think the third prong, which is like you have the time and the means to interact or intervene, and you don't.
Love that.
So I would say the first 2 are not right because of those reasons. Like, yes, you
Love
was
that.
cause for being negligent, but not enough.
Okay, I like it. And so that leaves you with C, but why is the answer not D, as in David? Why is the answer not the last one?
Well, because with contributory negligence, it looks at who caused it and who contributed to it. And so the negligence would lead to the contribution, so it would be relevant, but it wouldn't
Excellent.
be. So it would be relevant, but it wouldn't be the best of the 4 answers.
Excellent. Nicely done. Nicely done. Hopefully everybody gets it, right? Everybody gets it. We've got a clear situation. Well, I don't like to use. We have a situation where a young co-ed is driving, they're tired, they eventually decide to stop. They stop on a railroad track. Really? Of all the places that you can stop, you stop on the railroad track. Okay. Train comes along, but within that very short, and I'm actually going to go back so that you can see it. within that very short scenario, right? This isn't a really long scenario. It's not going to take you long to read it. In that very short scenario, if you look at the second piece, a trained engineer sees them, right? So we've got a defendant who sees that a person has put themselves in harm's way, right? I see you on the track. The trained engineer is far enough away to do something, so they've got the means and the opportunity. They just choose or refuse not to do it, right? And now it's too late to do anything. The train conductor or engineer blows the horn, but by that time, it's too late for the train to stop, and it's too late for the young woman who maybe hears the horn now to actually move off the track. So that is what the doctrine of last clear chance actually looks like when you've got people moving in it, right? As opposed to just the words on the page. Great. Questions about contributory negligence? We've got the basic contributory negligence doctrine. We have the rebuttal of the last clear chance doctrine to the contributory negligence doctrine. If it's a question that is focused on contributory negligence, the question is going to tell you that you are in a jurisdiction that recognizes contributory negligence. Questions? Nope. It's that easy. It's that easy. Let's get to comparative negligence. We know that contributory negligence was harsh. So we had some doctrines to try to take the sting out of it. Well, maybe those doctrines worked, maybe those doctrines didn't work. So you've got some states that just say, we're going to do something completely different. We're going to do a comparative negligence doctrine. And before you ask, we're not going to focus on 49% comparative negligence modified, 50% comparative negligence modified. We're simply going to stay with just pure comparative negligence. We're going to make it real easy. Pure comparative negligence allows a contributorily negligent plaintiff the opportunity to still be able to recover some damages, right? Because we know that the plaintiff has contributed. We know that the defendant has contributed, right? But now we're going to compare the contribution. We're going to compare the contribution, okay? In a comparative negligence jurisdiction, pure, right? We're looking at the comparative amount. What percentage was contributed by the plaintiff? What percentage was contributed by the defendant? And whatever was contributed by the defendant, the plaintiff gets to recover it. Pure. Here's a really extreme example. What does that mean? Does that mean if we've got a case where we've got a plaintiff who sues for negligence, establishes their prima facie case of negligence, yeah? And then we have a defendant who says, my defense, comparative negligence, you're negligent too, right? And the defense establishes their primary facie case, right? And let's say we have the comparison of fault where the plaintiff is 99% at fault. The plaintiff, the person who's claiming injury, is 99% at fault, and the defendant is 1% at fault. Can the plaintiff still recover in a pure comparative negligence jurisdiction? Yes. Yes. Pure. It's pure. It's pure, right? It's pure. So the plaintiff can be 99% at fault. The defendant can be 1% at fault. The plaintiffs can still recover. Now, how much is the plaintiff going to recover? Whatever that 1% is worth. But they still get to recover. That makes sense, right? We're not looking at 49% where the plaintiff has to be less than. We're not looking at that. We're not looking at 50% where the plaintiff can be 50-50. We're not throwing any of those teasers in there. This is pure. Got it? All right. In a pure comparative negligence jurisdiction, a plaintiff's percentage of fault, so it can be equal. It can be more. Got it? No restrictions. Okay. Here's a question. Let me stop the share. Let me get to the poll. Let's poll it. Comparative negligence. Yep. Let's launch the poll. We've only got 50% participation, so I'm going to wait for a few more to jump in. %77%. %84%. %96%. Let's wait for one more person. We're waiting for 2 people. All right, those 2 people don't want to give it to us, so let's end the poll. Let's share the results. 77% of you chose C. Richard will recover 30% and Joanna will recover 70%, which is correct. 16% of you said B. Richard cannot recover because he is more than 50% at fault. 5% of you chose A. Richard and Joanna will be found 50% at fault. Why is C the correct answer? Comparative negligence jurisdiction where it's pure. Doesn't matter if I am less than responsible, more than responsible, equally responsible. In a pure comparative jurisdiction, I'm going to get whatever percentage I didn't cause. Mr. Bernard.
I'm sorry, I was just going to answer it.
Oh, yeah, no, sorry. That one was pretty easy. Got it? I'm concerned that 20% of us didn't get it. So hopefully for the 20% who missed it, it was oh my gosh, I read it too fast. Oh my gosh, I wasn't really sure. Oh my gosh, I don't understand this as much as I need to understand this. So I'm getting ready to go back and read these few cases that we did at the beginning, right? Which there's still time to do, right? Plenty of time to do. Don't, just because you're not getting it right, don't panic. There's still time to figure this out. Okay. Questions about comparative negligence. You will see in the question that it's a comparative negligence jurisdiction. I will not leave that to you to guess. We're only doing pure comparative negligence. So you shouldn't, the analysis that fires when we're trying to figure out if the plaintiff is equal or more or less, that part of your analysis shouldn't fire because we're doing pure. So it doesn't matter if the plaintiff is more or less or equal, right? Okay, nice. Let's move on. Assumption of the risk, everybody's favorite topic. 10:45, I do not know if Dr. Bell is going to come in at 10:50 or not. So we're going to go for 5 minutes. We're going to end class. I'm going to ask you guys to exit the room, right? And whatever I don't finish live, I'm going to continue to tape and get through it, since we're already doing it on Zoom, I'll finish the explanation and then I'll go ahead and post the video. So assumption of the risk. Remember, two kinds: expressed, implied. Expressed, implied. If you're going to be tested, for me, on expressed, you're going to be looking for an agreement. Okay. While in life, it's not always an agreement. 99.9% of the time it's an agreement, but in a testing environment, for my test, 100%, you're going to be looking at an agreement. And it's going to be an agreement where the plaintiff agrees, accepts the risk that's created by the defendant's activities, right? How do we determine if that agreement is going to be enforced? From a public policy, real world perspective, we look at two things. We look at, is it against public policy? And is it good law to enforce this specific one? That's a general public policy perspective. Let's look at here's a question perspective. Here's a potential test perspective. Expressed assumption of the risk. It's a situation of contracts. So put on your contract brain when you see an expressed assumption of the risk question. Put in your contract brain. I know you guys have learned this in contracts, right? This is the Turnbow v. Ladner case. This is the Turnbow v. Ladner case. This is the guy who used to be a scuba diver, let his certification expire, wants to be certified now, right? He wants to be certified now, so he goes to the class. The class says, in order to participate in the class, you got to sign a waiver. He talks to a friend who's a lawyer. The lawyer says, signs the waiver because that stuff's not enforceable anyway. He signs the waiver, right? Goes out, gets the bends, decompression sickness, gets it so significantly, his days of scuba diving are done forever. It's over because he was so negatively impacted with the decompression sickness. He sues the woman who's teaching the class. She says, I signed the waiver. You signed a waiver, remember? Because what are we doing? We're looking at defenses, right? He proves his prima facie case. Duty, breach of duty, causation, both proximate and actual, and damages. She says, I don't care about your prima facie case. I have the defense. You signed a waiver. Well, let's look at the waiver, right? Because courts don't like people signing away their responsibility, courts are looking at a couple of things, two specifically. Number one is the language that describes what's being waived clear and understandable. Number two, was there an opportunity for the parties to negotiate the terms? Or was it just this boilerplate language, everybody signs the same waiver, right? One, clear and understandable language. Two, parties have an opportunity to negotiate. If those two things don't exist, the agreement's not going to be enforced, which means it's a failed defense. It's a failed defense.
Can you say the second one again? You said the first one was clear and like understand language. What was the second one you said?
Parties have an opportunity to negotiate the terms. Parties have an opportunity to negotiate the terms. What does that mean? That means I give you a piece of paper and says, if you don't sue me, I'll teach you how to scuba dive. And you said, well, I won't sue you in exchange for you teaching me how to scuba dive. However, you got to make sure that you're going to do one, right? There's some negotiation, there's some conversation, there's some back and forth, right? You're looking for that in the fact pattern. If the only thing that the fact pattern gives you is, I'm going to teach you how to scuba dive as long as you don't sue me, and you say, great, I'll sign the paper, there's no conversation, there's no negotiation, there's no back and forth. the second prong didn't get satisfied. Yeah.
Thank you. Yes, ma'am. Thank you.
Absolutely. Absolutely. That's a good place to stop. So what I'm going to do is ask you guys to go ahead and close up, ask you guys to go ahead and exit the room. I'm going to put the recording on pause. I'm going to give you guys a chance to clear out of the room. And once you've cleared out of the room, I'm going to unpause my recording and I'm going to go back through, pick up where I left off, finish this recording with this PowerPoint, and then post it. On Wednesday, we will start class with any questions that you have from the remainder of this PowerPoint. Ms. Dirtes.
I have two questions. So for the express assumption of risk, so you only want those two prongs, like basically the first one that must be clear and precise, and the both parties must have an opportunity for to negotiate. Because I have like parties agree in advance that the plaintiff will relieve the defendant of their legal duty towards the plaintiff.
That's inferred within the negotiation.
Okay, so just as long as I have those two things, the
Yes.
two that you mentioned, and the
That's
other
what they're going to look like
question-
in a testing situation. Yes.
Okay, understood. And I just wanted to know if you could explain, because I tried Googling it and learning more, but the absolute defense, the difference between the affirmative defense and the absolute defense, like, is there a difference between the two?
I don't understand that an affirmative defense is a defense that has to be proven.
Okay, with evidence, understood. So is that, because this one said on the slides, it said it's an absolute defense.
It should have been, it's a
So-
complete bar, would have been a better term.
Okay, so complete bar. So it would bar the other party from recovery, period.
The plaintiff.
The plaintiff, if these two things are proven.
Right. So, right. Because it's a defense, right? So I'm going to show that number one, we had an agreement and you signed it. Number two, the language in the agreement is plain. And number three, we had an opportunity to negotiate. So if it was something you didn't like about it, you didn't have to sign it.
Okay, sounds good. Thank you.
Thank you.
I'm sorry.
I had a question also, Professor Washington.
Yeah, if you're outside the room, ask me any questions you want to ask me. If you're outside the room, ask me anything you want to ask me.
So, as far as I did a hypo and I sent it to you, do I need to text you or do I need to not re-email, but do I need to set up a particular time for us to go over it?
What did you email me?
A hypo that I did?
Yeah, we can, if you, I actually forgot I had a hearing at 11. Yeah, let's set up a time to do that.
Okay, do you want me to email you or just
Yes,
text you?
email me.
Okay, I'll do that. At the
Okay.
SULC?
Yeah, because I completely forgot that I actually have a hearing at 11 and I've got the judge calling now. So I'm not going to continue I will continue when we stop, once I get done with the hearing. And Ms. Bass, what I will do is I'll shoot you an email to say, hey, I didn't have my camera on. Ms. Bass, were you asking about the hypo?
Yes, ma'am.
Yeah, so as soon as I get done with this telephonic hearing, I will shoot you an email. And if it's a good time for you, we can jump on another Zoom and we can go through the hypo.
Okay, that'll work.
Yeah, all right, Mr. Adams.
Hello, Professor.
Hey.
I had a question for the last clear chance doctrine.
Yes.
So I was getting confused with how, I guess I was hanging on to the last clear chance name a little too hard, because when I'm looking at the elements, it's not necessary that you prove, oh, they had the last clear chance to avoid this situation, as long as you can prove the 5 elements and that the plaintiff themselves didn't have those 5 elements satisfied, you can pin it on the defendant.
Well, it is kind of the last clear chance, right? Because element 1 says the plaintiff got themselves in a situation that sucked for them, right? Element 2 says, oh, the defendant saw it and realize that you're in a sucky situation. Element 3 says that the defendant saw that you were in a sucky situation. It could have done something to help you, but chose not to. Element 4 said, don't know why they chose not to, but they just freaking refused to help you. And element 5, and even though they had the means to help you, they didn't. And element 5 is like, oh, hell, you just got hurt.
I see it. I see it now. Yeah, thank you. Okay.
Right? So it is kind of like the defense has the last
Oh, right
clear
there.
chance
Yeah.
to really save the day once the plaintiff has put themselves in a really bad situation.
Yes, ma'am. Thank you.
Yeah. All right. Awesome. Let me go ahead and end this. Let me jump on this telephonic, change my jacket real quick, jump on this telephonic hearing. Miss Bass, as soon as I'm done with this hearing, I'm going to email you. And if it's a good time, you just let me know and we'll jump on.
Okay, that's fine. Thank you.
Awesome. Thank you, guys.